Hi, everybody. Thank you for joining the webinar on the Rahimi case. My name is Dr. Deirdre Bowen, and I am joined by Dr. Ellison and Mr. Jordan Ferguson and Dr. Julie Kafka. We will be taking turns discussing various aspects of the Rahimi case. The oral arguments are tomorrow before the Supreme Court. Before we get started, I wanted to just introduce my colleagues in a little more detail. Julie Kafka is a postdoctoral scholar working with the Firearm Injury and Policy Research Program at the University of Washington. She studies applied solutions to address intimate partner violence. She received her MPH and her Ph.D. from the Department of Health at the Gillings School of Global Public Health at the University of North Carolina, Chapel Hill, where she was awarded the Dean's Distinguished Dissertation Award for her project, examining the link between IPV, firearms, and suicide mortality. Dr. Ellison is an assistant professor in the Department of Pediatrics School of Medicine at the University of Washington. She is also a faculty investigator in the Firearm Injury and Policy Research Program at UW and a faculty investigator in the Center for Child Health, Behavior, and Development at Seattle Children's Research Institute. Dr. Ellison received her MS and PhD in economics from the Department of Economics in the College of Social Sciences and Public Policy at Florida State University, where she was trained in applied microeconomics, econometrics, health economics, and law and public policy. And finally, retired Sergeant Jordan Ferguson is associated with the Spokane Regional Domestic Violence Coalition. Mr. Ferguson has been with the Spokane Regional Domestic Violence Coalition since January 2023. Before that, he was the sergeant for the Spokane Police Department Domestic Violence Unit since 2016. He was with SPD since 1999. He has provided training to several law enforcement agencies on strangulation training and lethality assessment programs. He has been an instructor with the Battered Women's Justice Project, the International Association of Chief Police, and the Alliance for Gun Responsibility on the intersection of firearms and DV. He completed his MA in criminal justice at Washington State University with an emphasis on neuroscience and the effect fear has on humans. So the roadmap for our presentation today begins with Dr. Kafka and Dr. Ellison contextualizing for us the significance of the Rahimi case by exploring the empirical work regarding domestic violence and firearms. I will then dive into the legal part of the story and explaining potential legal arguments. And then finally, Sergeant Ferguson will finish out discussing the implications on the ground if Rahimi turns out to overrule the relevant statute and what that would look like in a more real-world aspect. All right, thank you, Dr. Ellison, and Dr. Kafka, please take it away.
Thank you, Dr. Bowen. Dr. Kafka and I deeply appreciate being invited to share the research that's relevant to the Rahimi case as part of this event. Just so you know, we're going to go back and forth to share this evidence that we think is important for the discussion. Just to start at a base level so that we're all on the same page, domestic violence is a substantial public health and safety problem with lasting consequences for individuals, families, and communities. The most common form of domestic violence is intimate partner violence, or IPV, which is a pattern of abusive and controlling behaviors by a current or former romantic, dating, or intimate partner. IPV can include sexual violence, physical violence, stalking, and psychological abuse. The vast majority of people, mostly men, who harm their partners also coerce and control them by doing things like making threats, controlling financial resources, and monitoring who their partners see and where they go. In the US, more than 41% of women and 26% of men experienced physical or sexual IPV or stalking in their lifetime. About 1 in 5 homicide victims are killed by an intimate partner, and there are severe consequences. IPV survivors experience adverse health events like depression, post-traumatic stress disorder, and chronic health issues. Not all groups of people in our society are impacted the same by IPV. Nationally representative data show that multiracial, American Indian, Alaska Native, and Black women disproportionately experience both IPV as well as its consequences. And IPV doesn't just hurt intimate partners because the violence often extends to other family members. Research has long found that many people who harm their adult intimate partners also harm their children. Relevant to the Rahimi case, firearms play a consequential role in IPV. The use of firearms are a key tactic of coercive control and threats and intimidation. For example, a partner might say something like, "If you leave me, I'll shoot you and the kids." Julie and I have heard this a lot in our research. This can be paralyzing for victim survivors. Evidence suggests that the health effects of IPV are worse when partners use these kinds of firearm threats.
Research provides specific information about these firearm threats. We know that about 4.5 million women in the US have been threatened with a firearm by a partner, and 900,000 have had an intimate partner who shot them or shot at them at least on one occasion in their lifetime. So this is a widespread problem. Tragically, firearms are also used to kill in this situation. In terms of fatal risk, over half of the time when a person murders their intimate partner in the United States, they use firearms. The risk that someone will kill their partner increases about 5-fold when the partner using abusive and controlling behaviors has access to a firearm. Firearms also add an extra layer of danger for children living in families with IPV. When a person kills their intimate partner with a firearm, they are much more likely to kill other family members, often including children. People who use violence against their intimate partners or family also tend to use violence outside of the home. And this connection is most clearly illustrated in recent data about fatal mass shootings. Over 2/3 of fatal mass shootings in recent years have been tied to domestic violence, meaning that the shooter either killed an intimate partner or family member as part of the mass shooting event, or that person had a clear history of prior non-fatal domestic violence.
Given this lethality that Dr. Kafka is discussing and its prominent use of firearms within IPV, federal law prohibits individuals who are subject to a domestic violence protection order from possessing or purchasing a firearm. A DVPO is a court order that's issued by civil or family courts. These are sometimes called protection or protective orders or restraining orders. In most cases, to obtain a DVPO, the person who's experiencing IPV, or the petitioner, files a petition detailing their experiences, and the court grants protections to help keep them safe from the person who's harming them, the respondent. DVPOs can include many forms of protection, like restraining the respondent from contacting or hurting their partner, excluding them from specific locations like a shared apartment, and specifying visitation arrangements with children. DVPOs generally offer faster and more flexible protections for a victim survivor compared to pressing criminal charges. There's a lower burden of proof to obtain a DVPO compared to criminal proceedings, and DVPOs are often ordered in a matter of days or weeks, where criminal proceedings take months, sometimes years. Victim survivors who petition for a DVPO have often tried many other informal solutions before they request these legal protections. DVPOs are one of the only victim survivor-initiated legal interventions that address IPV in the United States. And importantly, research shows that DVPOs are effective. They're associated with reductions in abuse, especially physical abuse. On average, victim survivors report feeling much safer after a DVPO is granted, and these orders can provide an important lifeline for victim survivors looking to escape an abusive and dangerous relationship. We know that DVPOs are an important tool to address very serious and often recurring violence. Most DVPO respondents have been involved repeatedly with the criminal legal system, including prior arrests or incarceration. In some cases, there are a string of prior DVPOs against the same respondent by either the same or different partners. The most dangerous time for a victim survivor is when they try to leave their partner or confront a family member about ongoing violence. So, making sure that DVPO respondents are not armed after an order is granted is a critical opportunity to provide real and meaningful protection.
I'm gonna kind of close us off talking about what we know about domestic violence protection orders and firearm restrictions. Studies show that ordering a DVPO respondent to relinquish their firearms while the order is active may prevent that respondent from killing their partner. State-level firearm relinquishment laws are associated with a greater than 11% reduction in intimate partner homicide rates. And importantly, 2 studies have found that it's vital for DVPO respondents to be required to relinquish firearms. Since the Rahimi decision, calls to the National Domestic Violence Hotline have increased from the 3 states in the Fifth Circuit where that ruling has been applied. There is widespread anxiety and fear about the consequences and the potential consequences of the Rahimi decision for both victim survivors, their families, and their advocates. According to opinion polling data, most Americans do express support for DVPO firearm restriction laws. Our job as researchers is to investigate data to rigorously understand cause and effect. We can't quantify what will happen in the future, but from our research and our personal experiences, we worry about what the Rahimi decision may mean for our country. In the most severe scenario, more people die because an abusive partner or family member is able to access and use firearms. More people will be able to threaten their partner with firearms, and these threats will carry more weight. Firearms are among the most deadly weapons available. Some victim survivors may continue to stay in unhealthy or dangerous situation because they can't get the protections they need to leave safely or stop the abuse. Our hope is that US law will recognize the very real dangers posed by IPV and the very real protections needed for victim survivor safety and well-being. Evidence clearly shows that these are urgent situations that should be treated with gravity. We're anxious to hear more from Dr. Bowen and Sergeant Ferguson about the legal arguments and the impact on practitioners for this important upcoming decision.
Thank you so much, Dr. Kafka and Dr. Ellison. So for this next portion of the presentation, I'm going to get into the weeds of the legal arguments associated with the Rahimi case. I do also want to remind you that we have a 15-minute Q&A at the end of our presentation, and we welcome you submitting your questions at any time. So to get us started, I want to begin with what brought the Rahimi case into existence. And so to begin with, what I want you to understand is that the Rahimi case involves one single individual, Mr. Rahimi, who is being he was convicted of violating a particular statute. The statute he is violated of he has been convicted of violating is USC 922G8. This is a federal statute. Now, he is bringing this claim before the Supreme Court after it went to the Fifth Circuit because he is arguing that the USC 922G8, the federal statute, violates his Second Amendment rights under the Constitution. So I want to be very clear here that the Fifth Circuit agreed with Mr. Rahimi that the statute does in fact violate his constitutional rights, and therefore the conviction should be thrown out. And it is now before the Supreme Court because the government is appealing the Fifth Circuit judgment. All right, what exactly happened here? What happened is Rahimi was subject to, as Dr. Ellison mentioned, what's called a civil protection order. Sometimes they're called restraining orders. But the key piece to understand here is this is a civil action, not a criminal action. So this meant a private individual who he was abusing had to go to court and establish in a petition a set of behaviors that Mr. Rahimi was engaging in, and the court issued a protection order. Now, in issuing that protection order, under a certain set of circumstances, the federal law applies, which bans certain individuals from owning guns only, and this is also really important, only during the period of time that this protection order is in effect. So what that means here is that in order for 922 G8 to apply to Mr. Rahimi, there has to be a court order that was issued, one, after a hearing in which the person received actual notice and had an opportunity to participate. Second, that order has to do something very specific, which is restrain a person from harassing, stalking, or threatening. And again, it's only applies to an intimate partner of that person or a child of that intimate partner, or engaging in other conduct that would place that intimate partner in reasonable fear of bodily injury to the partner or the child. And finally, the finding from the lower court that issues the protection order has to demonstrate that there has been a credible threat to the physical safety of such intimate partner or child, or the order explicitly says you may not attempt use, threaten use of physical force against a partner or child that would be expected to cause bodily injury. So that's the statute that's being challenged right now. It's a small subset of the statute being challenged on Second Amendment grounds. Why? Because the statute did apply initially to Mr. Rahimi. A search was done and guns were found in Mr. Rahimi's house. That then created a criminal violation of the federal statute. So let's begin now by looking at in what ways does 922 G8 potentially violate the Second Amendment? Let's start with, well, what does the Second Amendment say? So the Second Amendment says a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Okay, in that language, what ends up being the main focus of analysis is the language, the right of the people, specifically the people. So what happens here in this case is that initially the Fifth Circuit agreed and said, yes, this statute is completely valid, but then all of a sudden we have a plot twist. And the Supreme Court issued another gun case called Bruin. And in the Bruin case, what the Supreme Court decided was the way that courts have been engaged in analyzing whether statutes were in fact valid under the Second Amendment was not accurate. And so they developed a new process of analysis. And that process involves two steps. So Bruin comes into play and says, here's a two-step analysis that should be followed. And then the Fifth Circuit said, we need to follow those rules. And once they engaged in the analysis of this two-step process, they determined that the statute did in fact violate the Second Amendment. So what I want us to think about in terms of focusing what is likely to happen in tomorrow's oral arguments, it's going to involve, number one, understanding that the nature of the analysis in this challenge is not specific to a violation of Mr. Rahimi's rights because of the specific facts in his case. Rather, what Mr. Rahimi is arguing is that the statute, the federal statute that resulted in a criminal conviction for Mr. Rahimi, is on its face, meaning just simply looking at the text of the statute, it violates the Second Amendment. So in order for us to understand how the court might think about this issue, let's start with step one from the Bruin case. So what the court is likely to do is take a look at, first and foremost, the language of the people. So when we talk about the Second Amendment, it doesn't apply to everybody. It applies to the people. And the question then that's going to be argued is, what does the people mean? Who does that apply to? The significance of this is as follows. If the court determines that people who are similarly situated to Rahimi, meaning people subject to domestic violence protection orders or restraining orders, does not apply to them, the Second Amendment does not protect people of that population, then the analysis can stop and the statute will automatically be deemed constitutional. It will be upheld. That's the step one analysis. And it sounds kind of easy, except what the two parties are going to fight over is as follows. The government is going to argue that the people is not broadly interpreted, but rather the language the people has been more narrowly interpreted in precedent cases by the Supreme Court dealing with the Second Amendment and gun rights. One case that the government is going to bring up is Heller. And in the Heller case, they're going to say that the Supreme Court in that case said the Second Amendment applies to law-abiding, responsible citizens. So it is not the people writ large, but it is qualified by law-abiding, responsible citizens. In addition, the Bruin case, also decided by the Supreme Court just last year, uses the language ordinary law-abiding citizens. What's interesting is that the government has really hung their hat on the Heller language, focusing less on the law-abiding part and more on the language of responsible citizens. Let me explain why that's important. Keep in mind that the law-abiding piece would require an individual to no longer have Second Amendment rights if they have been criminally convicted. So we already know felons are banned from having access to firearms, and that came about because of a criminal conviction. However, in this case, the banning of firearms to individuals who are subject to a domestic violence protection order or a restraining order are not criminally convicted individuals necessarily. Instead, they are subject to this order because another individual whom they were abusing brought a petition to the court under a civil action. So it is not a criminal action in which these individuals were arrested and then the police referred the case over to the prosecutor's office and the prosecutor then pressed charges. That would be a criminal case. Here, it is not making a determination that a criminal conviction has occurred. 922G makes the determination, are you subject to a particular type of protection order that allowed for you to have notice and participate in a hearing that prevents you from engaging in stalking or other threatening behavior against an intimate partner or a shared child. So in this case, the government has to focus on this word responsible and what does a responsible citizen mean rather than law-abiding. From the government's perspective, responsible requires you to look at the language of whether the individual reflects a real threat or a danger of injury to others. Now, with that standard in mind, they argue it clearly fits within the finding of a domestic violence protection order respondent, meaning the person who the protection order is issued against. What they're saying is it's obvious that if we have gone to a hearing in civil court in which the petitioner has had to provide evidence of this threat of harm, and the respondent has had the opportunity to be heard and present their own evidence to suggest that they are not creating a threat or did not threaten or cause harm, then we clearly have a situation in which a lower court has found this threat of harm and that those individuals are not protected by the Second Amendment. Therefore, the statute remains constitutional. not so fast though, because the Rahimi lawyers are going to say, look, the Fifth Circuit got this right. The Fifth Circuit said, look, the people is read in a broad term. And the only situation we're going to look at is outside the textual words, the people. We're going to look at the historical pattern and practice and understanding of both who the people means, but also who is excluded under this language of the people. And what the Fifth Circuit and Rahimi found, or Fifth Circuit found, but Rahimi is going to also argue, is that there's only two clear situations in which there has been a long-held history in the United States as it relates to gun regulation where the Second Amendment does not apply. And that involves people who have been convicted of a felony, and it involves people who have been determined to be mentally ill in some form or fashion. Now, they are saying, Rahimi is saying, and the Fifth Circuit saying, we only have a clear pattern and practice of those two subsets of individuals not fitting into the protections of the Second Amendment. However, the government has a rebuttal to that, which is to say, if you look at the pattern and practice of what the individuals who are included and protected by the Second Amendment versus those who are not, you have to look at a broader understanding of who is excluded, and it is not a narrow definition of just those two categories. But again, even if the court says, as agrees with the Fifth Circuit and says, you know what, Rahimi, he's not a nice guy, but so far he's not a convicted felon and he hasn't been found to be suffering from some sort of mental illness, then he would be included in the group of people who are protected. Their rights are protected under the Second Amendment, which means then that the court is going to go to the second part of the analysis. The second part of the analysis is where the court says, okay, we understand that you, the government, are able to engage in firearm regulation, but that regulation has to be consistent with historical traditions of firearm regulation. Now, this is where it gets really tricky, because under Bruin, the first thing that has to be decided is, how do we figure out what is a historical tradition of firearm regulation? So listen carefully, because this is really getting nuanced. So what this comes down to under Bruin is whether the particular societal problem that's being regulated associated with firearms, is this a generalized societal problem that's been around for centuries? Or is it a novel, new societal problem that was not contemplated at the time that the Second Amendment was drafted? So what this turns on is as follows. On the one hand, Rahimi is going to say domestic violence has been around for the same amount of time that the country has been in existence. This is not a new problem. So if that's the case, it's a generalized problem, then under Rahimi, it is a requirement that the government has the burden to show a historical analogy of regulations from that time regarding domestic violence and firearms. The problem is that doesn't exist. So the government, on the other hand, is going to argue that's not what's happening here. We're not looking at the problem of domestic violence writ large. We're looking at a novel problem. And the novel problem that wasn't contemplated is the nature of domestic violence and the use of firearms, specifically the radically increased rate of domestic violence homicides by firearms. And what they point to is a historical analysis that showed domestic violence in earlier centuries did not involve firearm usage, and particularly did not result in homicide in the way that it has in the United States in the last few decades. So in that sense, they're framing domestic violence and the use of firearms as a novel problem. If it's a novel problem, the standard changes a little bit. Now the government does not have to show specific analogs under Bruin showing, look, this is the nature of the regulation that occurred with regard to firearms and domestic violence. Now Bruin says, look, we are not going to look for a historical twin. We don't expect you to come up with an historical twin. What we do expect is for you to come up with representative historical analogs. So we're not looking for language that's going to mirror what was on the books in 1729. Instead, what we're going to look for is language that demonstrates that there's been a pattern and practice of regulating dangerous people. And again, that circles back to a long history in the United States of regulating dangerous people in a variety of ways, but also not dangerous people. So what the government's pointing out is that we've regulated and banned people from firearms who were deemed loyalists, or people who were deemed unsafe because they just simply happened to carry their gun around in a threatening manner. You could ban them from using their guns. So under those circumstances, what you should watch for tomorrow is a situation in which the court is either going to spend more time really trying to understand the first part of the test, which means they wouldn't need to determine whether the law is valid because it doesn't apply to DVPO respondents, meaning people subject to domestic violence. On the other hand, pay attention and see if the court asks more questions about the pattern and practice and history and tradition of regulating firearms for particular populations found to be dangerous, and whether that's what responsible means in terms of whether it applies or not. So in this case, the one last thing I'm going to say to you is there could be what I would call a Hail Mary pass. The one room for compromise is that the court says, you know what, we're going to look at the other argument that the Rahimi brought up in their brief, which is that we don't actually need to discuss whether the Second Amendment is valid, whether 9222G is valid under the Second Amendment. Instead, they're going to argue the government, the federal government, didn't have the authority under what's called the Commerce Clause to actually enact that legislation. And in fact, it's up to the states under what's called police power to enact their own individual state laws banning firearms. Okay, I'll stop here and introduce Mr. Ferguson to talk to you about the implications.
Thank you, Dr. Bowen. And it reminds me of an episode from MASH where I can say, doctor, 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 and my only good response is go Cougs. The ground level looking at this is understanding what victims go through when they're going through domestic violence. This is not a gun issue. This is a domestic violence issue. It's not a gun grab. It's a temporary removal of firearms from someone who at that point in time shouldn't have one in their possession. Why are firearms so important? Is because they're effective. They work. In my career at Spokane, I reviewed over 20,000 domestic violence reports. Repeat victims, repeat offenders, victims that had been strangled 5 times, 10 times, but never victims that had been shot 5 times or 10 times. Firearms work, and that's why when someone is out of control, we need to work to get those guns out of their hands at that time. I was teaching an unrelated class in Texas talking about this. They're kind of a strong firearm state, and it was two police officers. And I got the folded arms and the faraway looks. And one of the senior detectives in the front row turned around and said, "Hey, you wouldn't give keys to a car to a drunk, and you wouldn't give keys to a classroom and a pet to a pedophile. So what's your issue on taking guns away at this point in time?" And it was a beautiful way to put it because that's what we're trying to do here. So many people will say, well, what's a protection order? It's just a piece of paper. It's not going to stop a bullet. Um, and you feel sorry for people that think that way because, if we thought that, we'd have a little paper on the front of our police uniforms that said it's illegal to shoot a police officer. We don't do that. We know it's not going to stop a bullet. But when you're talking to a survivor and she goes to court and she fills out that order and the judge reads it and the judge agrees and the judge grants the order, the sense of empowerment that happens there, it's overwhelming. Uh, with I mean, they feel like somebody believed me, I can go on with my life, I can make a difference. And the more you talk to them, the more you realize what these offenders have done to demoralize them, take away any sense of self-confidence that they had. So the protection order is such a beautiful, empowering thing for the survivors, and to get the guns away because they will do everything that you've heard in the highlights. They will threaten them with the gun. They will take the gun out and clean it right in front of them. They will point the gun at them. Uh, it's just it's terrifying what some of the victims go through. Getting the officers to understand the importance of the protection orders has been a challenge, and I so appreciate, you know, Dr. Ellison, Dr. Kafka, and the research they do in trying to understand. And I understand the reluctance that law enforcement has. Say, great, here's another academic that's going to come in and look at us and tell us what we're doing wrong. It's like, yeah, it's just like if you go to the doctor and the doctor says, you should probably lose some weight. Of course, it's the doctor's fault that you're fat, right? And it's not. But you need good academics, you need good studies, you need this kind of research to understand exactly what's going on. Um, the other thing I want to get across is the notion of a third. So one of the things that's happened the last few years with the defund the police and these movements that are going on is the use of force that police officers have. Well, in every study I've looked at, in every agency, 1/3 of their uses of force start off with a domestic violence call. So if we could stop the domestic violence, have the orders enforced, get people away from that's going to slow things down. 1/3 of the officers killed in this country every year are killed because of domestic violence, and 1/3 of the women in this country have been the victim of domestic violence. So those are things that we really, really want to, you know, stop and make it, make things simpler for people. Um, with the victims and getting themselves believed in the court, Spokane has a good process with an amicus that responds to the court on the compliance hearings on the orders, and that works on the state level. On the federal level, it's like, okay, so why do we need a federal law on this? Well, it's the same reason we need federal laws on other things that we have federal laws on. It's because the way this country was built with counties and states, where something might be illegal in one spot, another, not in another, and then jurisdictions and cross. If we have a person with an order that lives next to Washington and Oregon, and they're possessing a firearm, threatening their victim, the chances of a Washington law enforcement agency being able to arrest this person are slim. It almost may never happen. So being able to utilize federal statutes to hold these offenders accountable is critical to the mission that we're doing on this. So we need the federal law. The federal law is effective. And even without the law, it is the difference it makes in the victims' lives to be told that they're believed by a judge and an order is being issued. And the fact that, a victim from West Virginia can get an order and travel to Spokane, Washington, and if he follows and violates the order, that order is recognized across all 50 states, including into Canada, and they're protected. So yeah, it gives them a sense of relief. It gives them the chance to start their lives. It gives a reset to everything. So the research, thank God you guys are there doing that because it drives me nuts. And I appreciate you all very much. But on the ground, having that resource there is so huge and it makes such a difference. And with that, I'm going to go ahead and turn it over to Dr. Bowen and we'll go from there.
Thank you so much, Sergeant Ferguson. I really appreciate your contribution, as well as Dr. Ellison and Dr. Kafka. We're now at the part of our presentation where we welcome questions from the audience, so feel free to submit those. I will begin by reading the questions that we have right now and go ahead and attempt to answer those. So the first question asks, if Mr. Rahimi was prosecuted under a federal statute, should his side be successful, what should we expect the trickle down to state level look like on their domestic violence firearm prohibition laws? Well, if Rahimi is successful, let's just clarify, what does that mean? If he's successful, that would be a determination that 922 G8 does in fact violate Mr. Rahimi's Second Amendment rights, and therefore it is no longer valid. If that federal law is deemed no longer valid, meaning that we cannot take firearms away from individuals who are subject to protection orders, then it will also be the case that state DVPO laws that are similarly situated in terms of removing firearms in these civil cases would also be deemed invalid because they would violate the Second Amendment. That is what we're likely to see. And so, as Sergeant Ferguson is pointing out, regulating both at the federal level and the state level is incredibly important because of the access that someone can get a protection order in one state, but then go to another state and access a gun simply because if we did it on just the state by state level, if that state doesn't have that firearm restriction law, then they are free to get the gun in that state. So in this particular instance, not only is it harmful for individuals in the states in which the firearm removal DVPO law already exists, but here it applies federally, means that that law would be effective in every state, and that would now stop. And so the risk increases substantially. Okay, so the next question we have is, there is a similar case in Washington state called State v. Flannery. Are you able to speak to how Rahimi could impact Flannery? Yes, I certainly can try. So in this particular case, just to get everybody up to speed on what the Flannery case is, that involves sort of two competing things that were going on. One is that Flannery involved an individual who was both criminally charged with second-degree assault related to a domestic violence action. In addition, the court issued a no-contact order against Flannery that included an order to surrender weapons. Flannery said, I'm not going to comply with this order and I will not turn over my weapons because at the state level, Washington state does have these DVPO order to surrender weapon laws. At the state level, again, not federal level, but at the state level, it raised the question of the Court of Appeals. Then it hasn't gone to the Washington State Supreme Court yet, so it's just at the Court of Appeals, suggesting that our specific Washington state law violates his right, Mr. Flannery's right, not to incriminate himself by having to admit either by turning over weapons that he had weapons that he should not possess. So if Rahimi is upheld, it is likely to provide some level of clarity to Flannery, because it would essentially say DVPO order to surrender weapon laws violate the Second Amendment, and therefore judges and commissioners that are currently confused about whether to continue to issue those orders in Washington state would be able to point to Rahimi to say the Supreme Court has spoken on this issue and it's no longer valid under the Constitution. Now, the other situation, like what if Rahimi is not upheld? That makes things a little more complicated, and what will really determine how Flannery will play out is the legal basis that the Supreme Court determines that the 922G, the federal statute, remains valid. So there will be a different outcome if the court says, look, the people, meaning step one of that Bruin analysis, the people does not include people subject to DVPOs because they are dangerous. Why are they dangerous? There's been a finding of a threat of violence or harm to an intimate partner through a civil proceeding. And that meets the definition under Heller that it's not the people, it is law-abiding responsible people. So under those situations, Flannery would not have a Second Amendment protection because he's not within that pool. However, if the court says, no, it's true that the people does apply to people like Rahimi and Flannery. They're not great guys, but they don't fit within the traditional historic pattern of felons or people who have been adjudicated as suffering from mental illness, then it becomes a slightly more complicated manner to figure out. In essence, we can do an order to surrender weapons, but the nature of how we're going to engage in the implementation and enforcement of that law would still be up for grabs in Washington state because of the nature of the sheriff having to show up and potentially do a search, or the defendant on his own having to admit, I have these weapons and it's violating my Fifth Amendment rights, but only in cases where there is a concurrent criminal case does his Fifth Amendment right come up. So that's what makes it more complicated, is Flannery had both a criminal piece going and a civil piece going. So sorry, that is a very long answer for a very complicated situation. Okay, we've got a few more questions. It was reported today that Mr. Rahimi sent a letter to the judge today. This probably has no impact on the legal care before, or the legal case, I imagine, before the Supreme Court, but is there an impact on the narrative his attorneys are trying to argue, both in the court as well as in the social narrative of gun removal laws within the DV context? So I'm going to suggest that that question might be answered by Dr. Kafka or Dr. Ellison, whether there's a different narrative that would be explored given gun removal laws within what we know about the domestic violence context when this particular defendant has sent a letter to the judge. Do you have any thoughts about whether that changes the narrative, increases the risk, decreases the risk associated with people like Rahimi and domestic violence and guns?
I haven't seen the letter, and so this is new to me, and so it's hard to kind of comment on how that might change the legal landscape. What we do know is that people who are abusing their partner or abusing family members often have a history of repeated abuse behaviors. This is usually not a one-off situation, and so there is very clear evidence from the public health side of things and from the research side of things that these are pattern behaviors that I think could be argued that these folks pose a threat of interpersonal harm and therefore maybe might not be construed as responsible citizens. It's hard to make the value or understand the legal implication So I'm afraid I would have to know a little bit more about the nature of the letter.
Yeah, I will also echo what Dr. Kafka has said. I think the context of the letter might matter, but I will also add that manipulation and coercion are part of this pattern. And so we know that the use of those kinds of behaviors happens in DVPO hearings, as an example. So there will be a narrative that's told, and there often is an overabundance of the use of words to try and convince people that they're reasonable or responsible, that you should understand why I'm doing this and that it's your fault. And I think it wouldn't surprise me if those kinds of manipulative tactics are also being used here.
Sergeant Ferguson, did you want to add anything? I don't mean to put you on the spot.
No, that's the case. I was researching some of this, and I believe he sent the letter back in July, because he wanted to be done, because he's sorry, and he promised never to touch a gun again for the rest of his life. And it broke in the news in the last day or two, that he had done that. So yeah, the whole coercive control. Okay, I'm sorry. Well, I mean, it's really, I'm sorry I got caught, and I'm sorry I'm going to prison for decades. Not I'm sorry that I did it.
And I will just add to all of that is that what Mr. Rahimi does or doesn't do is not applicable to this case, because remember what the legal standard is. The legal standard here is, does the text of the plain language of 922G8 violate Second Amendment rights? Just the plain language, not as it's applied to Mr. Rahimi specifically, but just that statute as written, does it violate the Second Amendment? So in this case, Rahimi's behavior is not specifically relevant. Okay, let's go to our next question. Does the research that Doctors Kafka and Ellison were referring to include statistics on how often respondents actually surrender firearms when ordered to understand a DVPO? In my personal limited experience, all they have to do is say they don't have any. How often do they lie? And is there any sort of check going on to verify that they don't have any firearms to surrender? Further, does an active protective order prevent them from legally obtaining a new firearm? That is a fabulous question for Dr. Ellison and Dr. Kafka. They are doing a lot of research in that area.
Yes, I'll speak to this, but I think Sergeant Ferguson has a lot of details that he can provide from on the ground experience. So in terms of does an active protective order prevent them from legally obtaining a new firearm? Yes. So that is a DVPO is something that will flag in a background check if a state has a background check system that they are not legally eligible to purchase a new firearm. In terms of the research on how often respondents actually surrender firearms when they're ordered to, how often they lie, and is there any sort of check going on? As Dr. Bowen mentioned, Dr. Kafka and I, and actually the entire group here, have a lot of research going on in this area. As you all know from the conversation, Washington State does have one of these laws, and there are different implementation procedures across the state. We have done some research in King County where the claims of respondents are very actively vetted by a unit. And Sergeant Ferguson actually is someone who set up that kind of unit in Spokane County. So I want him to attest to that. We have research that's ongoing to really measure this in 4 different counties across the state. So I think we'll know more in the next couple of years. But I think Sergeant Ferguson's on the ground info is also helpful here.
Thank you, Dr. Elson. And that's so exactly right. And the question is so right on that before anybody started checking into them on their compliance, it was, yeah, okay, we believe you. We believe you. We don't know. In Spokane, we did it a different way than King County did. King County did a great thing with the unit. I mean, they backed it up with going in and doing research and saying, look, these 83 people said they don't have guns. We have evidence that 64 of them did. We need to start this unit. We didn't have that opportunity, so we did it a different way, but we went from a 4% compliance rate to a 96% compliance rate. And it has been just amazing to watch somebody come into court and say, I don't have guns, and have our compliance person say, I have a Facebook post from 2 weeks ago with you holding a Glock. I have a Facebook post from you a month ago holding an AR-15, and holding them accountable. And that's what you need, somebody that can get that information to the court to say they're lying, hold them accountable.
Okay, I think we have time to sneak in one more question. Dr. Bowen vaguely talks about historical tradition of firearm regulation. Do you know if there's any weight in the more recent legislation controlling firearms, such as the National Firearm Act of 1934, rather than the historical context of 1789? The justices seem to gloss over this and other similar gun control measures. So that is an important question that really is something to look for in the oral arguments and the nature of the questions that are asked tomorrow, which is, if the court says, Bruin says we must go to step 2, we must look at the pattern and practice of the nature of gun regulations at the time of the Second Amendment and look for something analogous to that time period, then it would appear that 1934 would be too recent, and that they were really looking for regulation that was contemplated regarding firearms and removal of firearms at the time that the Second Amendment was drafted and enacted. So that really limits the time period that you could look at. The hopeful part, because I kind of want to leave on a hopeful note, is that the government was able to provide a large number of instances from that time period to show that the contemplation of regulating dangerous people perceived dangerous, people who had not even been adjudicated as dangerous, but they were perceived as dangerous. For example, they were sympathetic to the British during the war, that is the type of more generalized pullback, analogous type of regulation that would allow for this type of regulation where there is actual adjudication of dangerous behavior, and therefore 922G8 would be deemed constitutional. Okay, on that note, we have reached 7 o'clock. I'd like to thank Sergeant Ferguson and Dr. Kafka and Dr. Ellison for participating in this panel. And of course, I thank all of you for joining us for this webinar. I hope you all have a wonderful night and look forward to perhaps convening again in the future.